Supreme Court of August now session, the Honorable Chief Justice Robert J. Torres presiding.
Today, you may be seated. Will the clerk please call the case?
This is Supreme Court case number CVA24-013, Kamlesh K. Hemlani, individually and derivatively in the name of and on behalf of Radhi Puran Trust, Plaintiff Appellant v. Manu and Anita Melwani et al., Defendants Appellees. Appearing for Plaintiff Appellant is Attorney Thomas M. Tarpley Jr. Appearing for Defendant Appellee, Radhi's Foundation, NKA Radhi Puran Foundation, is Attorney Louis Yanza. Appearing for Defendant Appellee, P.D. Hemlani Foundation Limited, and Vasudev B. Hemlani is Attorney Rodney Jacob. Appearing for Defendant Appellee, Manu Melwani, Anita Melwani, Ishwar P. Hemlani, Vinod I. Hemlani, Yogita V. Hemlani, Estate of Parmanan K. Melwani, Radhi Hemlani Family Trust, Pacific Rainbow Inc., Safety First Systems Inc., Pacific American Title Insurance and Escrow Company, Chitra Hemlani, Sonia Hemlani, and Padi Kelly Daryanani is Attorney William R. Mann. Panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Tarpley reserves 15 minutes.
Thank you. Mr. Tarpley, you may proceed.
Good morning, Chief Justice, Justice Carbolito, Justice Merriman. May it please the court. This is an appeal of the Superior Court judgment to dismiss Kamlesh's lawsuit on the grounds of collateral estoppel. Namely because Magistrate Manabusan in the PDHF lawsuit district court in his findings and recommendations made a reference that the foundation is the beneficiary of the Radhi Puran Trust. And Judge Cherlahi ruled that Kamlesh is bound by this statement as a matter of law. Therefore, Kamlesh is being disloyal to the beneficiary because of his lawsuit and because he established a competing nonprofit charitable corporation. He therefore should be removed as trustee of the Radhi Puran Trust, citing statutes that declare that a trustee owes undivided loyalty to his beneficiary. The first issue.
Before we get into the merits, I want to just review the standard of review for collateral estoppel. You had argued that it's a conclusion of law that the court should review de novo. The appellees, the foundation argues that whether it's available is a question of law, but that if collateral estoppel is available, that we have to review the judge's decision for an abuse of discretion.
I understood that the removal was discretionary, and therefore they said that you would have to establish burden of.
Yeah, I'm talking about the collateral estoppel issue, not the removal of the beneficiary.
Okay, it's a matter of law. I think it's de novo. It was a summary judgment motion, which was the basis for the motion. That's our position. But I personally, I don't think it makes a difference if it's abuse of discretion or de novo. May I go?
Yeah.
Okay. The first of three issues I want to address in this oral argument is one, whether collateral estoppel is an available defense under Guam law, since the district court action was dismissed because the court had no subject matter jurisdiction, as PDHF lacked standing to bring his lawsuit because he had no special interest or relationship with the Radhi Puran Trust or the foundation. That was the ultimate decision. This court has made it clear in several opinions that when a court lacks subject matter jurisdiction, quote, its only course of action is to announce that it has no jurisdiction and dismiss the case. Quote, without jurisdiction, the court does not have the power to decide or opine on any merits issue, whether legal or factual, and indeed should not address the merits at all. that was stated in Comlish 1 appeal, paragraph 17, in adopting the U.S. The United States Supreme Court opinion of Steel Company, which rejected the Ninth Circuit's doctrine of hypothetical jurisdiction.
But in this case, as I understand it, the trial court was not looking at it as the district court case addressing the merits of the case. We're talking issue preclusion here, that they're collaterally stopped. Because in order for as I understand it, the district court to arrive at its decision that PDHF has no standing, it had to make a finding as to whether or not they were a named beneficiary or a trustee. And in the course of that analysis, it found that the foundation was the beneficiary under the trust instrument. And so that finding was necessary to determine the standing issue. So that doesn't go by the wayside in my mind.
Well, that's what the appellee is arguing, Your Honor, but they started out as a 12B1 motion. It was a facial examination, and yet the district court then ruled on many of the merits of the case, such that the foundation is defunct, finding it was not defunct as a factual matter. The appellees are claiming the court determined that the foundation is indeed the beneficiary of the Roddy Perrin Trust, and that PDHF is not the beneficiary. And these findings we submit are in excess of the court's jurisdiction.
Explain
this court,
but Mr. Tarpley, explain to me if the district court, in order to arrive at a decision on the jurisdiction issue, whether or not there's standing for PDHF to bring the lawsuit under the trust instrument, it makes certain rulings. Are you saying that those rulings that led it to its conclusion that it had no jurisdiction are also invalid?
it's as the Justice Scalia said in the Steel Company case. If you go on and decide any of those merits, it is just a hypothetical judgment. And so, but once they decide they have no jurisdiction, and this court has made so clear
No,
that it must stop right there and cannot go to any of the merits.
So they can
that goes as
relitigate.
to res judicata. I can understand the principles of res judicata not applying, but here we're talking something less than that. It's an issue that was analyzed, decided by the court, the district court in this case, in order to arrive at its decision that it had no jurisdiction. That's a little different in my mind.
Well, as I suggested in my brief there's Judge Marshall made a reference to a case that was applauded by Justice Scalia, who was very adamant about that's all that counts is the finding that there's no jurisdiction, nothing else counts. And I quoted some quotes from that Bender case, and it indicates that they need to make a record for appeal purposes, because in this case, Rodney Jacobs had objected to the findings of both the magistrate and Judge Marshall, and eventually did file an appeal of that case. So you have to have a record of that. And that is understandable, because I think that's just perfectly logical and consistent with Guam law, that unless that decision to dismiss is reversed, that decision stays, and all the other rulings in the orders are just beyond the jurisdiction.
I would agree with you if the issue before us was standing, if the issue was whether or not PDHF has standing in this case, whether or not that decision constitutes res judicata, but that's not what's before us.
Well, they're trying to say that there was a finding on the merits that the foundation is in fact the beneficiary. And I don't think that that was one even necessary for their decision to reach on the standing of the PDHF. But the steel company basically held hypothetical jurisdiction produces nothing more than a hypothetical judgment, the same thing as an advisory opinion. So it cannot be used as a sword against some remote party in a different lawsuit on the collateral estoppel grounds.
So
That's
you're
our-
suggesting that issue can be relitigated again?
Yes.
I mean, the issue of whether DHF had standing?
Well,
I mean, because you're saying once its subject matter jurisdiction is found not to exist or standing, that you can't go to the merits and therefore everything is dicta, including that determination?
well, actually, Judge Terlaki in his decision and order on page 8 held, and he cited 3 cases. He says a dismissal for lack of subject matter jurisdiction is not a judgment on the merits and is entered without prejudice. He quotes 3 cases. A dismissal with prejudice is an adjudication on the merits. And he cites a case for that too. And
I think of the issue before Judge July was whether or not PDHF has standing to bring a lawsuit in the Superior Court, and whether or not the district court case is res judicata or collateral estoppel as to the standing issue, the ultimate merits of the case. That's a different argument.
I don't see that as being an issue.
Well,
By Judge Terlaki, all he ruled on was a motion that because collateral estoppel, because Magistrate Manabusan referred to the foundation as the beneficiary, that's binding on Commerce, and therefore he owes undivided loyalty to the foundation, even though he is trying to stop and recover stolen property by these people, and that is going too far. But this court has repeatedly said without exception that once you have it established that there is no subject matter jurisdiction, that's all you can, that's all.
So assuming you're correct, and this court, our court here, is going to look in the first instance as to what this trust instrument says as to who the beneficiary is. The document says that it's the foundation that is listed there, and interpreting the document separately. Why is it that that is not the case? Well,
On that point, and I just say this as an aside, in my opening brief on page 18, I pointed out that Magistrate Manabusan pronounced that the actual beneficiary is, quote, the Roddy Foundation, a Guam not-for-profit corporation, unquote. That's a different name, a different entity than the association. And I said that the only reason why that is not res judicata on the foundation association is because the magistrate's comma is ultra vires dictum in excess of jurisdiction. But if preclusion does apply in this situation,
I'm getting away from that. I'm assuming that
so-called beneficiary doesn't exist.
Yeah, but I think as pointed out by, it was Mr. Jacob, we look under our trust law at the settler's intent. And it's quite clear that in 1990-91, PD, Hemlani, and Roddy formed an entity that they designated to be the beneficiary of the trust at the death of the second settler. And I have not seen that the PD Foundation, the foundation it's not that same entity that was intended to be the beneficiary. Now, your contention is, it's an association, not a corporation, and therefore that semantics should overrule the seller's intent. But that's not what Guam law seems to say.
Well, our position is the Guam law on this particular point of the lack of subject matter jurisdiction has been very clear without exception. If the court believes it has preclusive effects, I'll move on to another argument. And that the next one is Kamlish was never a party in the district court action. He tried to intervene on June 24, 2013, which the defendants opposed. Then on July 9, 2013, the Superior Court dismissed without prejudice as Kamlish's first lawsuit for lack of standing. Therefore, Kamlish withdrew his motion to intervene on August 2nd, 2013. And ironically, Roddy Hemlani died 11 days later, making Kamlish a successor trustee of the Roddy Byrne Trust. And once again,
The trust was a named party in the district court action, right?
which trust?
The Roddy Trust, or the joint trust between the two of them, that was.
I believe it was Roddy who was named. That's what I recall. But that fact is that Roddy died in
The
May.
trust that Kamlish became the successor co-trustee on
Right.
was named as a party in the district court litigation.
I recall that it was only Roddy, but I'll defer to the court, whatever it was.
If the trust was a named party, does that make Kamlish in privity with the prior trustees as a successor co-trustee?
No, because one, Roddy had died. She was no longer a party. And Kamlish should have been appointed at that point in time to be allowed to intervene and represent the Roddy Byrne Trust. He was trying to do that. He was a necessary, indispensable party. And that's what Judge Shalahi held, that Kamlish is bound as a successor trustee, but Kamlish should have been made a party to the district court action, especially if he's going to be bound to every statement made by magistrate and Judge Marshall in a decision that's a year after Roddy died. I mean, that's just simple due process. But the third point I'd like to make is collateral estoppel only applies when, quote, when an identical issue is raised in a later proceeding. That's the Zahman versus Lim Tiago case, and was actually litigated and necessarily decided in the earlier proceeding as People versus Angoko. In Kamlish's case, in front of Judge Shalahi, Kamlish raised the issue that the foundation is actually a charitable trust, not a beneficiary of the Roddy Byrne Trust, because it's not to benefit from the property it receives, but to hold it as trustees for the benefit of organizations and people in need of charity. I raised that argument. It's in ER 141 transcript at oral argument. Judge Shalahi did not address this, and neither have the appellees in response to these arguments I made in my opening brief. The RPT instrument identifies various beneficiaries by the word beneficiary, but not the foundation.
What difference would that make in terms of where the residual would have passed? Because it was very clear it was to pass to a foundation, whatever that foundation might be.
But if it's not a beneficiary, and is it a charitable trust? Because a charitable trust is not a beneficiary, it has beneficiaries. And so this only
what is that? I don't understand how that influences where the residual should pass to.
That doesn't make a difference. But what it does do is that he dismissed the case because he was disloyal to a beneficiary, because they seized on this passing reference to the foundation being a beneficiary. The issue was actually whether PDHF was a beneficiary, not the foundation. It was PDHF that had to prove standing. And the magistrate went through the checklist in the restatement. Are you a trustee? No. Are you a beneficiary? No. Do you have special interests? no, therefore you lack standing, we lack subject matter jurisdiction. And he dismissed the case on that. The issue was not unfocused that what the status of the foundation was.
What about the argument that he wasn't communicating with the other co-trustees? There was a lack of cooperation and, you know, under the standard citing 15 GCA 3317. So, you know, whether or not his interest was adverse to the interests of a beneficiary, because the foundation, as you're pointing out, is not a beneficiary.
Right.
So
That's right.
what about the
Well,
argument?
they were defendants in a lawsuit that we were bringing, and they were all against each other because Hemlani had brought a similar suit and settled out for $13 million. And they're being bad people. I mean, you can't, and you said that that Kamlish could do this on his own. He can go forward and try and collect in his winding up powers, anything that's been pilfered properties out of there, that's entirely legitimate as part of his duties. In fact, the trustee can in fact be held liable if he doesn't pursue to recover from bad acts that he knows about. And so he has a duty to do that. So, I mean, the semantic label of beneficiary was, as to the foundation, is really just collateral dicta. I think it's a misnomer. But it was important only to PDHF because that's one of the three things he had to be to have standing. They weren't concerned about the foundation standing. And so this wasn't important to the foundation till a year later when Mr. Yanza decided to use this reference and invoke the statutes to say you have to have undivided loyalty and therefore should be removed, even though he's trying to recover from them pilfered property. And I just think that that's not a good decision. Whether the foundation is a charitable trust or a beneficiary, it's an issue of law. The interpretation of written contracts. A charitable trust is not a beneficiary. It has beneficiaries. They cannot use that ground of disloyalty to a beneficiary legally because it's not. PDHF was a charitable trust, and so is the Foundation Association. So because this precise issue was not ruled upon by the district court, collateral estoppel does not apply to Kamlish. Precise issue of is the foundation a beneficiary or a charitable trust?
But if the foundation is designated as a beneficiary, when you look at its powers that is listed within its corporation association documents, it's for the purpose of acting as a conduit to carry out the seller's intentions of its entrepreneurship. And so why does that matter?
Because it's a trust, it's a charitable trust. And it says so right there. It's exclusive powers. They cannot benefit from this. They have to designate certain charities exclusively for this property. And it's held in trust. They say so. It's expressed right there. And nowhere
When you say there, it's expressed right there. Where is?
in the
what-
charter.
In the charter of
the
which,
foundation.
the 1990 foundation?
Well, even in
not
the
of-
amended one, they amended in 2010, changed the name, but they did not change the purpose of being a trust administered by trustees for the benefit of unnamed but designated charities. And so the whole foundation and interest of the foundation in bringing that motion was the fact of the reference to them being a beneficiary. But it's not. Both of them.
So
are
your
charitable trusts.
argument is that the 1997 trust instrument it does not, designates the foundation as the beneficiary to carry out the seller's intentions of charitable entrepreneurship, that it cannot be carried out by the foundation because of some limitation
No.
under the 1997 agreement?
It can be carried out as a charitable trust. That's what it was. I mean, if you take a look at the trust instrument, as I said, it refers to people as beneficiaries but not the foundation. And the foundation's charter, which was established by PD, establishes it as a charitable trust. So they're going to carry out those duties. And my client's duties as a trustee is to go after people who take property for their own family gain and their own personal gain, who are part of the foundation, and contrary to the intent of PD Hemlani. And the court has held that. That's Kamlish's duty. So he can't be disloyal and removed for fulfilling the duties that this court has proclaimed that was his wind-up powers and duties.
But the allegation is that the Keyshore established entity it was in nowhere contemplated by the Hemlanis, and that goes contrary to the seller's intentions also, and that creates some conflict.
The record is very clear on here that we have always maintained that that's a cypraise doctrine that is made by the court, and that if it turns out that Kamlish wins on his claims here, that he could go in for the court and have the court appoint a new designated trust to administer for charitable purposes. And we just established that to preserve that name, Roddy Foundation, a not-for-profit charitable organization. It didn't go anywhere. We're waiting for the case to be over. We would go before the court if he wins and make that argument, a cypress argument, that somebody else should do it. And
So it was never the argument that was intended to be the original
no,
I don't want to say beneficiary in deference, but for now, the recipient of the residual from the Roddy Puran Trust.
No. They have it. If we recover the property and we win this, they shouldn't be the charitable trust to give this to designated but unnamed charitable beneficiaries, because they haven't done that. They took the property for themselves, just of the complaint.
All right.
And at the end of the case, someone's got to become the charitable trust that does that administration if they get the property back, and the court could make the Cancer Society. That's what it's all.
You have 3.5 minutes left. I'll give you 5 minutes in light of the number of appellees that you have.
Okay, thank you, Your Honor.
Mr. Yanza? You have 15 minutes.
Good morning, Chief Justice Torres, Justice Merriman, Justice Carolino. May it please the court. The trial court did not err when it ruled that Kamlish, as a successor co-trustee, was collaterally stopped from relitigating who the beneficiary of the trust was. In reviewing Judge Talai's decision, the trial court below, he found that if a prior dismissal was for lack of subject matter jurisdiction, then the findings necessary to make that judicial determination has collateral stops on subsequent proceedings. Otherwise, any other parties can relitigate those facts, and it would be open to relitigation. Here, Kamlish does not get a do-over. The district court dismissed the case for lack of subject matter jurisdiction on the findings that PDHF was not a beneficiary of the trust and therefore had no standing. Therefore, the district court dismissed the case.
But what about the issue of whether the foundation was the beneficiary? I mean, it made the determination that PDHF was not.
Well, it did make a finding that the foundation was a beneficiary of the trust because this district court looked at the trust and it identified that Roddy Corporation, a not-for-profit corporation, was a beneficiary of the trust. No one litigated the issue about the merits of the case. All that Judge Manabusan looked at was whether or not PDHF was the beneficiary of the trust. Once he made that determination that PDHF was not the beneficiary of the trust, had no standing, therefore lacked subject matter jurisdiction. Thereafter, the district court made no other findings, no other issues, and dismissed the case.
But was there an actual finding as to who the residual distributee would be?
I don't think that's doesn't make any difference. That's a distinction without a difference. All that Manabusan did was look at the terms of the trust and looked at who the parties were, looked at Roddy Puran Foundation as the beneficiary.
But what if there was a factual dispute as to who the actual residual beneficiary of or residual distributee of the residuary trust was?
I don't think there was, well, who was gonna dispute it? The only one who may dispute it was PDHF. They didn't make that discussion. All they said was, I am now the beneficiary of the trust because Roddy's foundation is now defunct. That was the material allegations in its complaint.
But Mr. Yans, I thought it was your argument, and you're making me a little confused now, that in the district court case, PDHF said it had standing to bring the litigation in the district court. And the magistrate judge and Judge Marshall adopted the recommendation. Held that PDHF was nowhere named a beneficiary or a trustee under the 1997 trust agreement, and it was the foundation. And that's what Judge Terlahi latched on, that in making the determination that PDHF did not have standing, it found that as a result of that, that the beneficiary of the trust was the foundation. And that's what Judge Terlahi latched on. And now you seem to say that that finding does not make any difference.
I'm sorry if I meant that. Judge Terlahi was correct in making that, I guess, ruling based on collateral estoppel on the district court's findings. I'm not saying that Judge Terlahi looked at whether there was a residual trust or any other findings. Judge Terlahi was focused on whether or not the district court made a findings of who was the beneficiary of the trust. That's all the district court looked at, and that's all that Judge Terlahi, the trial court below, looked at. Any other findings was not looked at by the district court, nor did Judge Terlahi below.
Was there a determination that the foundation was defunct?
No, I don't think that was an issue, but
So
PDHF.
so if that wasn't an issue and the trust was defunct, because the court made a determination that PDHF Foundation was not an appropriate distributee because it wasn't named, and they were coming in arguing, saying, oh, well, since the trust is defunct, we should be the ones, and the court said no.
Well, I guess by implication, maybe the district court did look at that because there was two issues, two allegations that PDHF made. One was because the Roddy's Foundation is now defunct, therefore PDHF is now the beneficiary of the trust. So by implication, saying the district court said that PDHF is not the beneficiary.
Is there collateral estoppel in being able to argue that Roddy Foundation is a defunct foundation now?
But it is defunct now. I don't think that was
defunct. So therefore, it's not an appropriate distributee.
Well, there was never
Because
any.
you're saying that that was one of the issues decided by the district court, that Roddy Foundation was not defunct?
Well, I mean, if you look closely at the district court, R&R recommendation and Judge Marshall's adoption, never did they actually focus on whether the PDHF, I'm sorry, Roddy's Foundation was defunct, even though that was a material allegation that PDHF made in the complaint. So really what Judge Manabusan looked at was whether Roddy's Foundation was the beneficiary of the trust, but before it made any more findings thereafter, whether or not Roddy's Foundation was defunct, it never made that finding because all it looked at was whether first it was the beneficiary of the trust. Now, if it made another finding that Roddy's Foundation was defunct, that would have been mere dictum, because once it made a finding that it lacked PDHF was not the beneficiary of the trust and therefore lacked standing, it dismissed the case thereafter. It never made any findings that Roddy's Foundation was defunct, because that would have been mere dictum. Now, I wanted to also address the disparities that the court raised in Cavendish 2 on footnote 9. I don't think there's been a dispute about the charter that was received by Revenue Tax in 1990, and then which was filed again in 1991, and then the Revenue and Taxation finally issued, I guess, an incorporation certificate, erroneously naming Roddy's Foundation as a nonprofit corporation. So that addresses the disparity in number one, that there was only one charter that was filed. The second disparity that was raised in Cavendish 2 was the Scrivener's error. I guess there was a Scrivener's error in naming Roddy's Foundation as a nonprofit corporation because the Scrivener, I guess, looked at the incorporation certificate and assumed that Roddy's Foundation was a corporation. The second Scrivener error is that he or she actually named Roddy Foundation as the beneficiary of the trust rather than Roddy's Foundation. So that answers the second possible disparity in footnote 9. But Hamlish doesn't admit it's a Scrivener's error. And what he argues is that despite the clear language of the trust, and despite Roddy and PD creating only one foundation, that he ignores all of this and is arguing to the court, hey PD, hey Roddy, this foundation that you created is what not you intended. You actually created another foundation. That's what.
That doesn't seem to be his argument. His argument is that if it turns out that the foundation is defunct or is not in a position to be the residual distributee of the trust, that he's offering another foundation to serve in that role under the Cyprus doctrine. Not that the one that was formed later constitutes the original distributee of the residuary trust.
Well, I beg to differ. I believe his actual intent, his actual argument is that you, PD, Roddy, despite you passing away, or despite you writing the language of the trust, you intended to create another entity, Roddy Corporation, and not for-profit corporation. Now, he's asking this court to adopt this Cyprus doctrine to somehow permit Hamlish to create this new foundation. Well, first of all, if you look at Hamlish's complaint, he doesn't ask for the court to permit him to create another foundation, this fake foundation. He asked for a receiver. Now, I don't know what that means, what a receiver is, but he cannot unilaterally create another foundation in violation of the trust, in violation of the beneficiary, to rewrite this trust for his own personal gain.
I don't think that's what he's arguing.
Well, I think that
I mean, at least that's not what he's asserted today. He realizes that it would require the court's participation under the Cyprus doctrine in order for that to occur.
Well, if he was going to intend that, he should have filed some court special proceedings to permit him to create this foundation in I guess, in violation of the trust language. Instead, what he has done was not communicate with all the other board members, not communicate with any other trustees, and instead file this action without discussion with them.
What about the argument that the foundation is actually not a beneficiary under the terms of the Roddy Puron Trust because it's just identified as a residual distributee of the residuary trust? And therefore, the court was abused its discretion in determining that the provisions of 15 GCA 3317, which talks about acting contrary to the beneficiary's interest isn't appropriate.
Well, first of all, I think that's a distinction without a difference, because no matter what the trust said on this residuary trust, it's the settlers' intentions. And looking at their prior actions, all they did was transfer all these assets to the foundation. They gave money away.
But can the foundation benefit from those funds that were transferred to it?
Well, it's not supposed to benefit from those funds. And well, yes, it's supposed to benefit from those funds.
How does it benefit from those funds?
Because it's receiving the properties from the trust. It's the beneficiary. Then the beneficiary's intentions and goals, or objectives, are to pass those funds and transfers to other charities. And that's what it did. It fulfilled the goals of its own charter and fulfill the goals of the trust.
But does it identify the foundation as a beneficiary in the Roddy Puron Trust?
It does. I mean,
Where, can you point me to the language?
the trustees shall distribute the balance then remaining of the residuary trust to the Roddy Foundation, a Guam not-for-profit corporation.
Right, so it distributes the balance to the foundation. But does that, just because it just makes it a beneficiary, is that what you argue?
Yes, the remaining of the residuary trust, then to the Roddy Foundation of Guam Not-for-Profit Corporation. So I think it's pretty clear. Now, meaning Kamlesh, is trying to make these distinctions without a difference. It doesn't really matter. We have to look at the settler's intentions. Otherwise, we are rewriting the trust. We are disregarding the settler's intentions. As for the trial courts of abuse of discretion, I don't think the trial court abused its discretion. There was no erroneous application of the facts, nor misapplication of the law. It correctly followed the law, didn't use any misapplication of the facts. I really have no other arguments to make. I think I've covered all the arguments I can make regarding this case. I think, Your Honors, that the trial court's decision applying collateral estoppel should be affirmed. Does the court have any more questions?
Thank you, Mr. Pianza. Mr. Mann, you have 7.5 minutes.
That's Mr. Chief Justice, and may it please the court. Roddy Hemlani was not convicted of a crime. She wasn't involuntarily hospitalized, nor was she determined to be incompetent. That being the case, what right did the government, in the person of the public guardian, have to take away from Roddy her right to control her own finances?
Is that really an issue we have to confront here? I mean, we're dealing with the issue of the collateral estoppel that's been raised on appeal and the issue of removal of Kamlesh as a trustee of the trust. So those seem to be the two issues that are on appeal. I don't think the issue of whether the the government acted appropriately in curtailing Roddy's powers is an issue that we're addressing here, is it, Mr. Mann?
I would like to think that, but it was Mr. Tarpley that asked this court, cited this court to the public guardian report and asked this court to consider it. My response is this court should not consider it, in fact, should reject it. And so I'm responding to Mr. Tarpley's request. It's not an academic question. I'm responding to Mr. Tarpley's argument that the court should take the public guardian's report into consideration.
But that didn't have anything to do with Judge Terlahi's decisions that are on appeal.
That's very true. That's very true.
I think you made your point on the record by submitting your brief, but I mean, I don't want you to tell you how to argue your case, but I just see two issues in this case. One is collateral estoppel apply, as Judge Terlahi decided, and number two was Mr. Kamlish properly removed because he had a conflict of interest and he was hostile to the workings of the 1997 trust and carrying out those intentions. That's what I'm more interested in.
I defer to Mr. Lanza for all of those arguments. I'm only here to respond to Mr. Tarpley's argument that this court, in his brief, should take the public guardian's report into consideration.
That's duly noted to me.
I'm sorry.
That is duly noted in my mind.
Okay, I mean, I can stop at that point because I put my argument in the brief, and I believe it's important because of what did happen, and in fact, you have the government in the person of the public guardian actually doing these things with no determination of competency at all, as stated by the guardianship court, and it's our position that that's just wrong. And it would be wrong for this court to take that into consideration. And so that's really all I have to say.
You stated it very eloquently, Mr. Mann.
I'm sorry?
You stated it very eloquently.
Okay, I thank the court. I have nothing further.
Thank you, Mr. Mann. Mr. Jacob, 7.5 minutes.
Thank you, Your Honor. Good morning, Mr. Chief Justice and Justices. May it please the court. On behalf of PDHF and Hemlani, I am the counsel that filed the district court case. It remains to this day a disappointing and bitter loss, but that's what it was.
Excuse me, Mr. Jacob, could you put the mic a little closer?
Is this better, Your Honor?
Yes, thank you.
Yes.
I was saying that I was counsel that brought the district court case. I was counsel that brought the first case in 2009 that led to the MOS. I was just recounting that the district court loss remains bitter and disappointing. PDHF felt it should have won, and in those allegations and in the extensive litigation that ensued in the district court case, PDHF lost. It lost on the central question of the identity of the beneficiary. Contrary to what Mr. Tarpley argued in his brief and today, the question before the district court was not, is PDHF a better beneficiary than the Roddy Foundation? The question before the district court, which was built upon several years and several facts, a 500-page complaint with 37 exhibits, some from Judge Sokola's court, some from the public guardian, allegations that were made that were not just in good faith, but were grounded. We, on behalf of PDHF, specifically asserted that the foundation was defunct and terminated. The court can look to paragraphs 4 and 17 and our cause of action 15, which is paragraph 267 in the district court complaint. It was clear what we were asking. Again, it was clear that we lost, and I say that with a heavy heart. But what is equally clear is
Did
that
the
there,
district court make a determination that Roddy Foundation was the actual beneficiary and that it was not defunct?
yes, it did, Your Honor, and I will point out in the order where it did. As I'm doing that, I want to also point out and answer Your Honor's question, which said, are the stated beneficiary purposes laid out in the Roddy Foundation charter and in the district court opinion? And the answer is yes. To that question, the court can look to page 8 of the order, footnote 10. I'm sorry. I'll get right back to where that quote is, but getting back to the very central issue on what the court decided. The court decided on page 8 and
Can I
framed the,
Clear, Mr. Jacob, are you referring to Judge Manabusen's recommendation or the actual?
I apologize, Your Honor. I'm referring to the report and recommendation of Judge Manabusen in the district court on page 8. And that is at SER 174 in the Roddy Foundation's SERs. The court framed the question this way, and I'm reading from now on page 9 at line 3. If PDHF is neither the trustee of the trust, nor has it been authorized by the trust to bring this suit, the question for the court to resolve is whether PDHF is the beneficiary of the trust. The complaint alleged, as noted by the defendants, that PDHF is a beneficiary of the trust. And then the court goes on to say, although, and this is at line 15, although PDHF asserts it is a beneficiary of the trust, this mere assertion does not make it so. In reviewing the language of the trust, paragraph 5.05b states, upon the death of the surviving settler, the trustee shall distribute the balance then remaining of the residuary trust to the Roddy Foundation, a Guam not-for-profit corporation. It cites to our Exhibit 4, which is the trust instrument, which is the exact identical trust instrument that is set forth in Kamlish's complaint in this action as Exhibit 6. It's identical.
Yeah, I don't
And
think you can dispute that that is the language of the trust.
And then Judge Manabusen goes on and concludes, thus the trust expressly identifies the beneficiary to be the foundation and not PDHF. So as Justice Carbolito was articulating the analysis, it is exactly correct. Part of the court's analysis was necessarily to identify the Roddy Foundation as the beneficiary of the trust. So
But
it
the
could
court made no
determine.
determination that the foundation was not defunct.
It
Did it?
did, Your Honor. Yes,
Okay,
it did.
where is that?
On on footnote 12, which is on page 12 of the order. I quote, the court is unpersuaded by PDHF's claims that the foundation was, quote, defunct, close quote, and intended to dissolve. Louis Anza, counsel for the foundation, asserted at the November 22nd hearing that the foundation was not defunct and that its board members were intent on enforcing the MOS. That is a clear finding by Judge Manabusen that directly addressed PDHF's aggressively asserted and supported allegation that the Roddy Foundation was defunct, dissolved, and terminated, and addressed cause of action 15 that sought the appointment of PDHF as the beneficiary, as the sole beneficiary, because of the termination of the Roddy Foundation. We didn't dream that up, but it was rejected. And it was based ultimately, remember, Your Honors, and this is a dense record. I lived it. The action commenced in 2012 when Mrs. Hemlani was alive. That is in rebuttal to Mr. Tarpley's suggestion that somehow she was either a party or she had passed. She was very much alive when this case was brought. She was alive for almost 8 months. The guardianship, the public guardian was a plaintiff in intervention, Your Honor. To answer your question, the trust was a party. Judge Sokola issued an order that's in the record that says the public guardian is the trustee ad litem. Judge Iriarte, acting as an attorney with attorney Vince Camacho, represented the trustee ad litem and the public guardian. We brought this suit together. We lost it together. And the public guardian reports that are in the record say two important things about this. The foundation is defunct, and PDHF should be the charitable proxy. And contrary to Mr. Tarpley's comments that Vashi Hemlani and PDHF acted wrongfully, well, then how can it be that the final report to the public guardian determined that the MOS was valid as to PDHF, that it would be the charitable proxy, and in this case below on the summary judgment motion that I have brought that the court has not gotten to yet, the public guardian has supported it. And on top of that, the successor to Mrs. Hemlani, the special administrator of her estate, has entered into an arbitration award which confirms the MOS based on probate court instruction. The MOS as to my client is valid. It was valid in 2011. The identity of the beneficiary being the Roddy Foundation is critical to the consent that we have brought before this court and the lower court, and is very important to my client. It is untrue that the district court somehow had a preference of who the beneficiary was. It was untrue that the district court did not address the very question of identity, and it is untrue that it was not vigorously litigated with lots of evidence. There was 400 filings in this case. It was litigated in front of Judge Manabusin. It was litigated in front of Judge Marshall. Before the motion to dismiss was filed, I brought a motion for a receiver to protect trust assets that was opposed by everybody in this courtroom, including Mr. Tarpley, who now has the audacity to say he wasn't involved in the district court case. He opposed the receivership and the receivers who were Chris Felix and Cynthia Kuby. Here's what he admitted in a district court filing that is before the court and referenced in our brief. He says, "It is our opinion that PDHF lacks standing to implicate the Roddy Puran Trust in the federal district court. PDHF is improperly volunteering itself to be the beneficiary of the Roddy Puran Trust. A corporation simply cannot do that. It has no right or legally protected interest to be a beneficiary of a trust if the trust did not designate it as a beneficiary." Now I want to point this critical statement that he made in a filing. The trust documents designate Roddy's Foundation to be the beneficiary, which has its own internal problems. That is at PDHF RJN page 8. It is critical. He has taken the opposite position in this matter to defeat what clearly the district court had done. And he states not just what Your Honor very in what the law we have set out in our case says, which is the trust, if the trust was a party, you're bound as a successor trustee He claims he's a successor trustee. He doesn't dispute the law that Judge Terlahi cited, that he is bound as a successor trustee.
Your
But
time,
he had,
your time's
thank,
up, Mr. Jacob.
thank you, Your Honor. If there is no further questions, I'll rest on our briefs and thank the court for allowing me to appear remotely.
Thank you. You have 5 minutes, Mr. Tarpley.
Thank you, Chief Justice. Just quickly, regard to what Rodney was just saying. Again, the only actual issue decided and necessary in the district court to determine whether PDHF has standing is PDHF a trustee? No. Is it a beneficiary? No. Does it have a special interest or injury in fact? No. Therefore, they lack jurisdiction on that basis because he didn't have standing. It's not whether the foundation is a beneficiary or just a charitable trust. That's the precise issue that's in this case.
But you made the statements according to Mr. Jacob that the foundation is the beneficiary. And so.
That's semantics. I was just asked, I was not made a party. I mean, my client was not made a party. I didn't participate in the merits beyond that. But that.
But you don't dispute that you made those statements on the record of the district court litigation.
If it's on the record, I don't, but we were not made it, and we were not privy with them, and we were not a party. That was the point there. As far as the trust being represented.
But why, I'm still trying to understand why you're not in privy if you're a successor co-trustee. And the trust was made a party. I went back and I looked at it.
Okay. Okay. Why didn't they make my client a party then? Roddy died in May of 2013. She was out of there. The decision that came down, that's all at issue here, was 1.5 years later, December 2014. If we're going to be held to all those findings, which I say we're on the merits of the claim, we should have been made a party. And
but that's the law, Mr. Tarpley, that if a trust was made a party to the litigation, your client is a co-trustee, then it's held to what the consequences are, as that all the co-trustees are now are held to, and you can't pick and choose, you know.
Well, the original trustee was Roddy, and she died in 2013 May. She wasn't a party then.
Yeah, but then
so I'm in privy with her after she died.
You're in privity to the co-trustees that then succeeded.
Did any of the co-trustees enter appearance after Roddy's death as the sole trustee in the district court litigation?
They were not a trustee. Rodney, his client, was not a trustee at that time, and that's what the court determined. That's why he didn't have standing. And no one I know, we were not part of that district court action. We were there sporadically at certain times trying to get in. That's why we were there. And at the end of the case, there was a question of whether the property should go to the Rodney Perrin Trust or whether it should go to some other receiver. We were not allowed to be a party there. But I'm using up my time. I've said this. Mr. Mann brought up only one argument that he sat down on. His second argument is in the record, but he didn't discuss it. I just want to make one quick point on what he did say. I don't think it's properly before the court, that issue where he's trying to bootstrap a memorandum written by Jeff Cook back in 2010 and the arguments therein. And one of the arguments is that that oral agreements to annul a separate property agreement was okay under Guam law until that law was changed in 1980. This is deceptive, but somewhat in our favor because he is conceding that in 1980, the Guam law was changed. Oral agreements are not okay. In 1980 was when 19 GCA 6112 was enacted by the 15th legislature. But actually, it was just a repeal and reenactment of the old civil law. And oral agreements were not okay prior to 1980 because of section 178 of the old law says all contracts for marriage settlements must be in writing and executed and acknowledged or approved in like manner as a grant of land is required to be executed and acknowledged or approved. It's basically the same thing back then. That was enacted in 1953. Basically the same thing as 19 GCA 6112. So the law didn't suddenly change in 1980. It was just a reenactment of that provision, at least as far as that issue is concerned. That's all I want to put on the record for that. Thank you.
Thank you, Mr. Tarpley. Thank you, Mr. Yanza, Mr. Mann, Mr. Jacob. The court will take the matter under advisement. We will issue a written opinion and will now stand adjourned.
All right.
Your Honor,